Good afternoon, everybody, and welcome to the first Food for Thought session of the new year. Before I introduce our speaker for today, I just have a few housekeeping messages. As this is a live event, your microphone is going to be muted, so you won't be able to speak directly to Dr. Johnson. However, if you do have any questions, please do type them in the chat bar on your right-hand side of your screen, and I'm going to ask them at the end of the session. Today, we are going to be hearing from Dr. Hope Johnson, who will deliver a talk on regulating the future of protein, exploring the full range of regulatory issues with alternative proteins, whilst considering the current and future regulatory responses. Dr. Johnson is a senior lecturer at the Faculty of Business and Law and the Centre for Agriculture and the Bioeconomy with the Queensland University of Technology in Australia. She is a leading scholar in food law and policy. Hope uses a mix of empirical and legal methods to explore how to regulate food systems to improve public health and environmental outcomes. She draws on various areas of law related to food and agriculture, including food standards, international trade law, intellectual property, and environmental and planning law. Since 2019, Hope has pursued her research programme on regulating alternative proteins and has published in leading law and social science journals on the subject. From all of us at Food for Thought, we hope you enjoy, and I will now pass you over to Dr. Hope, who will begin her presentation.
Thanks very much, Lauren, for that introduction. So I'm going to be going through the definitions of alternative proteins today, charting the rise in research and development, consumer acceptance, and then looking at the full range of possible regulatory responses with a key focus on definitions of meat and dairy and emerging regulatory responses in the EU, the US and internationally. And finally, I'm going to cap it off with a quick look at Australia and New Zealand's response to the impossible products and the pre-market approval process that Australia undertook in that regard as a case study. In Australia, it's customary to acknowledge the traditional owners of the land before a talk or ceremony. So I'll begin by acknowledging the traditional custodians of the land on which I am performing this talk, which for me is in Brisbane, Meanjin, and it's the Turrbal and Noggara peoples. I pay respects to their elders, laws, customs and creation spirits. Now, alternatives to meat and dairy extend from traditional and comparatively unprocessed foods like beans, mushrooms and lentils to more processed alternatives like tofu, seitan and falafels. That form part of human diet since antiquity. The earliest reference to tofu as a meat alternative, or the earliest reference we have to a meat alternative is in the year 965, when Shi Ji, a magistrate in the Xinjiang region in China, emphasized the consumption of tofu over meat, referring to it as mock lamb chops. Going much further into the future, in the 1960s, advances in food processing technologies led to the creation of textured vegetable protein, or TVP, which is a precursor to the contemporary meat and dairy analogues we have today, and it became mainstream in Western markets by the US brands like Tofurky in the 1990s. TVP sort of results from industrial heating and moistening of extracted components from soybeans and peas until those extracts become jelly-like and then they're reshaped and dyed. We also have corn as another precursor to today's novel meat and dairy analogues as well, which I understand has long been within the UK market. Now, alternative proteins or novel meat analogues, it's just one of the terms that we use to describe a new generation of meat and dairy alternatives that has emerged over the last decade and are designed to mimic the sensory and nutritional experience of meat. So alternative proteins encompass processed insects, products that come about through advanced food manufacturing but don't involve biotech, so beyond beef products would be an example. And finally, products that come through advances in biotech technologies, namely precision fermentation and cell culturing. And I do dwell a bit on cell culturing because it is quite a different set of processes and outputs compared to the other alternative proteins and has its own unique regulatory challenges. So cell culturing is in particular is a way of growing animal muscle tissue using tissue engineering principles. It involves harvesting the cells from an animal, cultivating those cells in a particular medium, and using bioreactors to help grow the tissue, creating the right kind of environment and agitation of the tissue as it grows, and it often involves the use of scaffolds. At this stage in its development, often animal carcasses are still used or animal products are still used, such as fetal bovine serum. And so it's been a real challenge for companies in this space to overcome those barriers. But we have seen a lot of innovation in that space since then. So they're coming to scale now currently. So I'm using the term alternative proteins because it's what academics are currently using. Australian food regulators use the term novel meat analogues, novel dairy analogues. The term alternative proteins is not actually really ideal. It emphasises one macronutrient, which is protein, and there's no dietary need to emphasise one macronutrient. There's also a risk that, because a range of studies indicate that protein content claims on products have a health halo effect. So citizen consumers tend to think of products making claims to be high in protein as, especially good and may overlook other matters. It's also kind of confusing because some alternative protein products like Impossible Burgers contain a novel protein. So it kind of just gets a bit confusing as well, but we haven't quite settled on the right terminology. One of the key kind of things to think about when we're defining alternative proteins is whether or not they're ultra processed. Now, public health nutrition is increasingly focused on how types of processing affect the nature and quality of food. Increasingly, public health nutrition has evidenced a link between the degree of food processing and the overall healthfulness of food, which does mark a significant shift from a focus on individual nutrients and towards a focus on the whole composition of the food and the ways in which those various components interact with the whole food matrix. Public health nutritionists use the term ultra-processed to categorise foods that are produced only using industrial techniques and processes, and which are made up of substances including sugars, oils, fats, protein, starches, and so on that are derived from whole foods. Often they include things like flavour enhancers, anti-foaming agents, artificial sweeteners. Basically, it's foods that comprise of substances never or rarely used in a kitchen. And there is widespread agreement that the overconsumption of energy-dense, ultra-processed food is connected to diet-related non-communicable diseases. So food policy academics and advocates and regulators in high and middle income countries are looking at how to regulate ultra-processed foods. For instance, Brazil has introduced 84 bills since 2006 targeting ultra-processed food through various mechanisms, but none have actually passed to date. And there is some debate about alternative proteins and where they fit within this space, or significant debate about this. Yes, some alternative protein products are ultra-processed. Corn, for instance, could be considered. Another notable example is the Beyond Burger. Whether cell-cultured meat is ultra-processed is perhaps more debatable, given it's made from muscle tissue, but also involves novel inputs. Ultimately, there's two things up for debate here. Firstly, the scope and usefulness of ultra-processed food as a category, and then secondly, the nature of alternative proteins is whether or not they're ultra-processed products, especially compared to whole meat products. So both those things are worthy of further consideration and discussion. In terms of what caused this phenomenon, this rise in alternative proteins, why can we go down to our regular fast food outlet now and see plant-based options or other kinds of meat-free options? There's multiple intersecting factors that come into play here that really do overlap. So there's an increased scrutiny of the environmental impact of food, increased focus on healthy, sustainable diets across policy discourse in the media, etc. There's increased private investment in R&D, specifically food manufacturing R&D from private companies has exponentially increased. Supply chain development and expansion, improved products, more availability, and all of this leads into and is connected with higher demand. And finally, and perhaps more recently, there's been a creation of lobby and industry groups for alternative proteins that has also put it in the mainstream and also put it more on the regulatory map as well. So the UK is certainly not immune to these trends. According to ING Economics, the plant-based alternative market in the EU and the UK is expected to double in 5 years from 2020. Comparatively, the UK is one of the markets with the highest demand for meat alternatives, perhaps compared to other nations such as namely the US, it sort of lacks the same development base. Consumer acceptance studies in the UK indicate that the key factors for why consumers are choosing meat alternatives was fat content, carbon footprint, price, and country of origin. So that's the factors that were coming into play when they chose meat alternatives. Other studies indicate that most UK consumers associate meat alternatives like corn with health and sustainability related benefits as well. So let's consider the scope of regulatory responses on the table. So firstly, many alternative protein products will be subject to either pre-existing pre-market approval processes or new approval processes created for particular kinds of alternative protein products. So for instance, in the US, which technically does not have a pre-market approval process for most novel foods, is in the process of creating a pre-market approval process for cell cultured products. While in Australia, at least a year and a half ago, the food standards regulator here stated that existing pre-market approval process for novel foods will suffice for cell cultured products. But I'll circle back to what might be some of the key points for those kinds of assessments on the next slide. It also seems likely that each country will create standards around production and processing for precision fermentation and cell cultured products that focus on acute food safety risks. So for instance, it might be standards around avoiding cell culture contamination, standards about the qualities the bioreactors require, how often they need to be cleaned, what has to be worn in the facilities, what kinds of temperatures and other checks are required on a daily basis. Sort of similar to food manufacturing standards now, but obviously in a novel space. Depending on the jurisdiction, there may be inspection role for regulators. Certainly in the US, there's a significant discussion that the USDA will be involved in inspecting cell cultured products in a similar way that they're involved in inspecting the meat that's produced in the US. Right now in Australia, there are inspections in certain and in meat processing facilities in particular, so maybe that will be something that would carry through. Another key area will be fortification and reformulation requirements, which may or may not be imposed. So for instance, one recent study in the British Journal of Nutrition examined the nutritional implications of displacing meat with meat alternatives, which has actually not previously been done. And their results indicated that meat alternatives can be a good, healthy alternative if chosen correctly. So if citizen consumers choose meat alternatives that are fortified with particular nutrients like iron and B12, and if those meat alternatives were low in sugar, high in fibre, and so on. We can expect to see countries create standards around food labels and descriptors, which I'll circle back to in a little bit. And finally, we can expect regulation in the space to be shaped by court challenges to varying degrees, because it is an area that is contested, and we've already seen numerous cases in the US about these particular products, and of course in the EU. So what specific areas might a regulator be looking at when they're performing a risk assessment in on novel or alternative proteins? Most hazards identified to date are not novel to foods produced using biotech or to pharmaceuticals. So there are hazards that have been identified and addressed. These are sort of the same hazards that we've seen identified and addressed in risk assessment processes for novel foods using biotech and for pharmaceuticals. But the combination of hazards and the new inputs and processes used will require some new approaches beyond existing responses, and a lot more work is required on the potential chemical and biological hazards along each step of manufacturing cell cultured products in particular. What we know so far is exposure to hazards will depend on each particular set of processes and inputs used. Each alternative protein product actually differs very significantly in terms of inputs and processes. So one cell cultured product can be produced in a very different way from another. Some hazards are common throughout the process in the sense of, say, potential for contamination, whereas others are very specific to the type of input used and the stage of production. Some potential hazards might be bacteria, viruses from the source animal, the use of antibiotics and hormones, the particular method used to store cells, storage conditions, the introduction of contamination into the cell culture, which is actually a common issue in biomedical research, structural and chemical changes that might occur once cell cultured products are then subjected to processing to, say, turn it into nuggets and so on. One particular issue in this space is the reliance on industry-funded safety studies, and that's partly just because cell-cultured products and precision fermentation is largely occurring within privatised innovation systems, and we do not really have a lot of large-scale peer-reviewed and independent analyses of the safety of various processes. There's also IP preventing those kinds of analysis as well. So while regulators often rely on industry-funded evaluations for the safety of their products, this reliance on industry evidence has raised issues in both the US and Australia in various regulatory debates and could become more of a live issue as things progress, pointing to the need for independent evidence of some kind. In the Australian context, it was even raised by other government departments. So Singapore, you may know, was the first country to approve cell-cultured products. In December 2020, the Singapore Food Agency approved Eat Just Inc.'s cell-based chicken. Just is a Silicon Valley company that's been around since 2011. It has heavily invested in manufacturing within Singapore and developing its manufacturing capabilities there. Currently, you can only buy the chicken through a very exclusive restaurant, and the packaging, as I have been led to understand, you scan in a particular QR code on the packaging and takes you to a video that discusses the future of chicken. Now, in Singapore, published guidance regarding the safety assessment of novel foods specifically addresses cultured meat, similar to the EU, in fact. The document outlines information required to perform a safety assessment of these products. Essentially, to be approved for sale, companies have to submit safety assessments that cover toxicity, allergenicity, and dietary exposure, as well as details on the processing method and safety procedures. Underneath the Singapore Food Agency, there's a team of experts in various areas, food toxicology, nutrition, etc. They provide advice to the agency about whether to approve or disapprove on the basis of the application. This regulatory approval process involves no public consultation and does not feed up to further bodies for oversight. Is also very focused on acute biophysical risks as opposed to other factors that could feature in a broader risk assessment or regulatory process. As we saw with GM foods in Australia and the UK and other jurisdictions, narrow quantitative assessments based purely on scientific assessment without meaningful engagement with the broader public and without a broader range of stakeholders being involved is not optimal in these jurisdictions for ensuring public confidence or for identifying and evaluating the full range of hazards and issues. And this point is well evidenced in food governance literature and science and technology studies, including by a leading UK scholar, Andrew Sterling from the University of Sussex. So various emerging areas of law and policy regarding food also may influence alternative proteins. So for starters, there's been an increased push for public investment in this space that may influence the development, the regulatory uptake, and the kinds of issues and evidence that regulators have. This might occur in some nations and not others. So for instance, Israel, Singapore, and other countries have been very friendly towards public investment in, say, cell cultured meat, whereas Australia is probably not that positive on it yet in terms of investing or fitting it within a climate finance framework or something like that. Regulating for sustainable diets and introducing, say, estate-based or co-regulated eco-labels are increasingly part of the mainstream policy discourse. This is a very complicated area, so what is to be measured under an eco-label, what should be represented on an eco-label. Broadly, life cycle analyses tend to show alternative proteins are less resource intensive than other products, but they are more resource intensive than minimally processed fruits and vegetables and things like tofu and falafels. So watch this space. As discussed, emerging regulatory responses to ultra-processed food may also influence alternative protein products. And finally, developments in IP and competition law may shape the kinds of products being developed. And there is a preliminary study illustrating some consolidation in the plant-based alternative protein area that's worth mentioning as well. So a central focus of regulatory responses to date has been on whether alternative proteins should be able to use meat and dairy terms on their products and related imagery, including images of farms. Within this debate, there's two surface level sets of concerns. Firstly, there's a concern that citizen consumers are misled into purchasing alternative proteins believing they are meat. Secondly, there's this concern that citizen consumers are purchasing alternative proteins thinking that they are a nutritional substitute to meat and dairy when they may or may not be. The evidence either way is limited and conflicting. So there's consumer studies indicating consumers think alternatives might be healthier. There's no studies indicating that they think they might have the same nutritional composition necessarily. There are some studies in the US, Australia and EU that suggest consumers are being misled and do accidentally purchase alternative proteins believing they are meat and dairy. Those aren't in peer-reviewed journals yet. There's a few studies on milks that show that consumers can clearly distinguish between cow's milk and plant-derived milk. There's one empirical study in the US of 155 citizens published in 2020 in a peer-reviewed journal that found that if you removed words like milk and meat terms on alternative protein products, consumers will actually be more confused about what those products are and how to use them. Some regulators have determined that consumers are not misled by meat and dairy terms on alternative protein products, provided the label and marketing contains appropriate qualification that is prominent as other claims. US case law and Australia's consumer regulator, which is the ACCC, has certainly adopted this perspective that a reasonable consumer would not be misled. The first US courts have focused on, for instance, the fact that soy milk contains soy at the start, and so this idea that a discerning, even the least discerning consumer would understand that they weren't purchasing milk. Other regulators have determined that consumers could be misled and that there is a risk of this. Of course, we have the EU laws around this and the Tofu Town judgment in particular, where they do believe it's necessary to limit names for alternatives to ensure that consumers can clearly distinguish between these products. The US has been particularly active in regulatory responses to alternative proteins, which makes sense because it's a large meat and dairy producer and it's also a key developer of alternative proteins. Roughly 13 US states have laws preventing the use of meat terminology on products not derived from animals. The exact restrictions do differ, so some will allow meat descriptors provided the product label states just as prominently that it's not derived from animals. The level of specification around that does differ. Other states prohibit any meat terminology regardless of qualifiers. Some of the statutes only apply to cell-cultured meat, even though these products aren't on sale yet in US markets, and others focus on plant-derived alternative proteins. At the federal level, there has been a bill introduced called the Dairy Pride Bill that's currently with the Subcommittee on Health. It seeks to restrict the use of dairy terms on plant-based products on the grounds that consumers may be misled into thinking that they are a nutritional equivalent. So milk can be the idea that they are the nutritional equivalent to, almond milk and vice versa. Such laws have raised and could continue to raise different constitutional challenges in the US and say in potentially in other countries as well, under the US First Amendment, freedom of expression, especially where the law applies to all meat terminology. There is a key case in this regard by Tofurky, which was brought against, they sought an injunction against Arkansas statute that banned all meat terminology on meat alternatives. The injunction was granted on the grounds that the use of meat terms was not inherently misleading because the labels made it equally clear that the products were not animal derived. The court also noted that less restrictive regulatory avenues were available, such as requiring more prominent disclosures of the non-animal derived nature of the food or some kind of symbol that would indicate it was a vegan product. Notably, US case law indicates that confusion about the nutritional content of a product does not itself indicate that a consumer has been misled about the product's actual identity. So from a consumer law perspective, you're not misled if you think that the nutritional components of a product are different. And so that really does accord or align with US case law. In the context of cell-cultured meat, It all kicked off in 2018 with a public hearing on how do we regulate cell-cultured meat that went over 2 days. Really, it was a discussion of who regulates cell-cultured meat, because in the US, the US and USDA, and the FDA regulate different components of the food system. So if you think of a pizza that has cheese and meat on it, the FDA regulates the bread and the cheese, and the USDA regulates the meat. And so it was a really big discussion about who should regulate this and how. Following the hearing, the FDA and the USDA released a statement that said they would actually jointly regulate cell-cultured products. The FDA is to oversee the cell collection, cell banks, and cell growth and the differentiation process, which is understood to have particular safety issues that the FDA has more experience in, perhaps. The USDA will oversee the harvesting of the cells, the production and the labelling of these products, which is key because the USDA has an important role in labelling of meat products. FDA has made a call very recently for submissions on cell-cultured seafood naming conventions, and that's because the USDA doesn't regulate seafood. So we're waiting to see what the FDA decides about regulating cell-cultured seafood. And it's probably worth noting that cell-cultured seafood has particular concerns around allergies. The EU response, cell-cultured meat will need obviously authorisation from the European Commission on advice from the European Food Safety Authority, and it's already been recognised that cell-cultured meat and other kinds of tissue culture is a novel food requiring that kind of approval. And there's also the potential need for a parallel application for genetic modification if the process involves that. There's also been some complex restrictions in the EU around dairy terms that have been interpreted and enforced very differently. Of course, there's the famous failed Amendment 171 on the prohibition on words like creamy and buttery. And the EU is currently considering impossible products for approval, the application for authorisation of a new genetically modified food, and application for authorisation as a food flavouring preparation as well. So we should have some risk assessment deadline is the 16th of August. It's worth noting that the kinds of regulatory responses we'll see in this space will be shaped by what Codex ends up setting in relation to alternative proteins. In 2019, Codex flags that it will set standards in the future relating to the safety and labelling of cell culture products, but not alternative proteins more generally, which does make sense because it's a very broad category. I'd also expect more standards to emerge at the Codex level around insects protein, given the acute biophysical risks associated with their consumption. Now, under the WTO SBS agreement, member countries can impose more stringent food safety regulations than international standards, such as those set by Codex, provided the different standards are scientifically justifiable and otherwise consistent with SBS rules. If we're drawing on a WTO case about EU's restrictions on GM, which is informally known as the EC Biotech case, there is difficulty relying on the precautionary principle for justifying restrictions on alternative proteins in the face of scientific uncertainty. So in other words, regulators will have to broadly have a good reason to place additional restrictions or requirements on the sale of cell cultured meat or other alternative proteins that are supported by scientific evidence and focus on particular risk. So restrictions on cell cultured meat products to, say, protect domestic agricultural industries will be difficult to justify if and when Codex responds. So moving on to a case study now about how Australia and New Zealand are responding to alternative protein products, and I've already sort of briefly referred to the impossible products, but this was the first time that an Australian regulator and New Zealand regulator had to respond to alternative proteins through a proper regulatory process. Now, Impossible Foods have developed a way to produce heme iron at scale. Heme iron is an especially bioavailable form of iron that until now we've mostly consumed from animals. Heme iron is, however, present within a protein found in the root nodules of soy plants called soy-like hemoglobin. Now, Impossible developed a way of genetically modifying a particular strain of yeast and DNA from soy plant root nodules. The yeast ferments and produces a form of soy-like hemoglobin that is intermixed with some other ingredient, and this ultimate sort of product or preparation is called Leg H prep. So leg H prep contains this novel soy leg hemoglobin. Now, Impossible claims that the use of this leg H prep not only improves the bioavailability of iron in its products in a level analogous to beef, but that that this heme iron also contributes a meaty flavour to its meat products. So this novel protein gives its burgers iron, meaty flavours and smells, and because leg H prep is a ready liquidy brown colour, it's not cooked too much, it gives the appearance of a product that's bleeding. I'll take you briefly through Australia's approach to novel foods, and then I will have a look at what FSANZ, the food regulator, particularly considered in the Australian context. I should say Australia and New Zealand context. So briefly, Australia and New Zealand have the same set of food standards. We reached a treaty with New Zealand about how we would have the same set of food standards under what we just call the Food Standards Code. And the same regulatory body sets the Food Standards Code, which I'll just call FSANZ, which is the Food Standards Australia and New Zealand. FSANZ doesn't actually enforce food standards in Australia. That is left to the state level agencies to do, and the New Zealand counterpart as well. So in Australia, we also have a consumer regulator, which I briefly referred to, who actually can prosecute misleading and deceptive conduct in marketing. They're also called the ACCC, and so they'll also accept complaints about misleading labelling. Now, the Food Standards Code prohibits the sale of products that fall into certain narrow categories unless a product in those categories is explicitly permitted by a variation to our code. So a company essentially applies to FSANZ to vary the code to allow its products. To vary the code in response to an application, FSANZ has two possible levels, but generally these kinds of applications are major. So it must go through two public consultation processes, a risk assessment of the product, and a qualitative cost-benefit analysis. So FSANZ begins by conducting the preliminary assessment of the application, which involves considering all the information provided by the applicant, as well as a desktop review, and finally a qualitative cost-benefit analysis, which means it considers broad factors that the legislation indicates is important to consider and what might otherwise be relevant. FSANZ's assessment in each case has to be guided by particular legislative objectives, which are in order of priority. And the first one is to protect public health and safety. The second is to ensure adequate information to consumers. And the third is to prevent misleading and deceptive conduct. Following this assessment, FSANZ provides a report on the outcome of its assessment and seeks public submission. So it does this sort of preliminary assessment of whether or not it will vary the code, and it comes up with a sort of initial suggestion that yes, we will vary the code, or no, we won't. If it says yes, it then seeks sort of further information and insight that will then feed back into its risk assessment process and its qualitative cost-benefit analysis before it reaches a final decision. Once it reaches a final decision that yes, we're going to go ahead and approve this novel food, it then has to put together a draft variation and seek further public consultation. So it's at that point that the second consultation occurs. For Impossible, FSANZ decided that it did require pre-market approval after Impossible applied on the grounds that leg H prep was a food produced using a gene technology and that leg H prep was a nutritive substance that had not previously been approved. So in the US, although it has a very different approach, not quite a pre-market approval process, the FDA did categorize leg H prep as a food colouring. So that again is quite different to Australia and even the EU. Ultimately, this process took about a year in Australia, and FSANZ ultimately decided to approve soy leg hemoglobin in the form of leg H prep at levels up to 0.8%. So I'll take you through some of the reasons for its decision, about why it decided to approve it, and then I'll also contrast different points with an analysis that my co-author Christine Parker and I provided of the 61 submissions received. Now, 61 submissions might not sound like a lot of submissions to a regulatory process, but comparative to other novel foods in Australia, it actually is a high amount. Often they might not receive any, and FSANZ itself noted a high volume of stakeholder interest in this case, so or in this decision. So its first primary point that it emphasised and why it was going to approve this leg HPrep was the prior consumption of heme iron in the form of animal flesh, and also the prior consumption of soy products. This is notable because this reasoning that, you know, we can sort of vouch for the safety of this because we've consumed heme iron before and soy products before, was questioned in a US case by the Centre for Food Safety, which challenged the release of Impossible on the grounds that, among other things, regulators could not extrapolate from a history of consuming heme iron and a history of consuming soy that leg HPrep was safe. But ultimately that petition was dismissed by the court. And it also was not an issue that submitters raised in Australia. Fazance also relied on a toxicological study funded by Impossible that involved 28 days of feeding leg HPrep to 80 rats at varying levels. Submitters really contested this study. They raised concerns about the lack of dietary studies longer than 28 days, the lack of safety assessment of other kinds of protein that the yeast strain may produce, and the lack of data regarding the safety of leg HPrep once it was processed into, say, sausages, etc. A number of submitters, including other government departments, questioned the reliance by Fazance on this study that was actually funded by Impossible. And Fazance also focused, so that was sort of one sort of subset, but ultimately Fazance decided on the weight of the evidence was for approving. Fazance also focused on the bioavailability of heme iron because, again, it was also considering whether it would allow a leg HPrep on the grounds that it was a nutritive substance. And this formed part of its assessment, was how bioavailable was the iron. Now, submitters raised concerns about, as a whole, whether Impossible products were healthy, suitable replacements for meat, but this really fell outside of Fazance's focus on whether leg HPrep contained certain amounts of iron. Some submitters were somewhat concerned that then the Impossible products could then make claims that might distract from other things in the product, such as, you know, if it had high levels of sodium. Finally, in the cost-benefit analysis, Fazance emphasised that a new product on the market would increase revenue and increase consumer choice. What ultimately our analysis shows is that, similar to other novel food products, underlying alternative protein debates are much larger questions and conflicts about what kinds of food systems we want. And this presents a unique regulatory challenge, as government agencies and scholarship globally has documented that a lack of inclusive, deliberative and informed regulatory processes have previously undermined the acceptance of GM food. So it's a very difficult terrain for a regulator to be in, especially when they have to respond to the product in front of them, as opposed to these broader issues at stake. Now, there has been a spillover from, because this debate could not be contained, into other areas of regulated focus in Australia. In particular, there's now a Senate committee at the federal level that has been conducting an inquiry entitled Definitions of Meat and Other Animal Products. The inquiry is focused on the potential impairment of the Australian meat category by alternative proteins. Now, this inquiry has received over 200 submissions, and submitters are from all various parts of Australia. We have retailers, we have developers of alternative protein, we have the existing meat and dairy industry. So far, my preliminary analysis shows that the themes in these submissions are very similar to the themes raised by submitters and to the Impossible Burger approval process, and also raised in the US debates as well. Okay, so I might leave it there and hand over for questions and discussion.
Thank you, Hev. That was really interesting. We've got a few questions in the chat. Please do add some more if you want to ask anything. One of the big ones, there's been a lot of discussion around the healthier alternatives to meat and if they're more processed than normal dairy and meat products. And if so, are you aware of any consumer education that's going on or anything around to make people more aware?
I do know that there has been campaigns on either side to frame the products as not ultra processed or as ultra processed. But in terms of what Fazance could look at, that wasn't part of what it could consider. But I think it's going to be continuing to be an issue because a lot of alternative protein products, especially those that are plant derived, would fall within the category of ultra processed foods. It's worth pointing out that meat and dairy products are also used in ultra processed food production. So any regulatory response to say ultra processed food as a category would probably affect all sides of the alternative protein discussion.
Thank you. Does the appraisal of meat alternatives replacing meat in the diet include the bioavailability of vitamins and minerals in the fortified meat alternatives?
What was that one again, sorry?
Does the appraisal of meat alternatives replacing meat in the diet include the bioavailability of vitamins and minerals in the fortified meat alternatives?
Yeah, from my understanding, the study modelled various, there's one study to date on this particular issue, so obviously there's going to have to be a lot more studies on that. But what they found was if the product contained B12 fortification and iron fortification, and was also had those other attributes, that it could be a nutritional substitute for or could displace meat. That was one finding. So obviously there's going to have to be a lot more discussion in this space, and we can get into the complexity of whether the level of processing shapes the nutritional outcomes as well, which is obviously not for me to weigh in on, but certainly that would be featured within the debate.
Thank you. An anonymous person has written, the points flagged on ultra processed foods are very interesting. Do you think that alternative proteins may actually positively help to clarify that the concept of ultra processed food is far too simplistic?
Yeah, it's an interesting one because I would say within the food literature, there isn't a lot of discussion about whether the category of ultra processed food is simplistic, but it obviously challenges that category a lot, and certainly I've struggled to understand how well it fits within different things. So I think it's going to challenge it. I guess the issue would be if it reinforces a simplistic understanding as well, because if you have different stakeholders saying that their product is better because it's not ultra processed, that could, I guess, reinforce a sort of a simplistic idea of ultra processed. I do know the category is being teased out more with more clarification over time since it was first discussed and sort of picked up by the FAO. So perhaps that concept itself needs further clarification, but it is a challenging one to work with, and I do think that this debate is really going to bring the ultra processed food issue back into, or very much into, the public domain, which has certainly been a key theme in all of the regulatory discussions to date, and also from what I've seen in terms of how stakeholders are seeking to problematise alternative proteins.
Thank you. Anthony has asked, do you see a conflict of interest issue, actual or perceived, with the toxicology study for Impossible being funded by Impossible?
I think it's perceived. I mean, I couldn't comment either way, but it's obviously a peer-reviewed study published in a very credible journal. So I think it's a perceived conflict. I don't think it matters, and a lawyer would tell you it doesn't matter if it's an actual or perceived conflict. I don't think it matters because what matters is the perception of a conflict, even if there is or is not one, because we want consumers to trust that food regulators are doing their job well. And the doubt that was raised about this study and the over-reliance on one study that was funded by a particular group is enough to perhaps raise questions of legitimacy and credibility. And so I think it's enough that stakeholders were raising this as a concern, and that it has been raised across the various regulatory discussions around alternative proteins, both in Australia and the US, for it to be an issue worthy of further deliberation. It is difficult because regulators don't necessarily have the resources to conduct their own independent analyses. And as I said, private companies are the main developers of these products, so they're in the best position to conduct the assessment. So certainly it's an issue that regulators will see, I think, again in this space.
Well, thank you. That's all the questions we've had through. I'm just very conscious that it's late for you in Australia. Well, we're just about to go and have our lunch, so thank you for that. It's really appreciated, and I've definitely learnt a lot, and I know my team at Food for Thought have as well. If anybody's got any final questions, please do post them now. If not, we can always email Dr. Johnson, and I'm sure she will send any answers over. But
Well, that'd
thank you
be
very
excellent.
much.
Yeah, I would love any discussions about this topic. It's obviously an area of great interest for me. So anyone who wants to further nerd out on this, I would love that. That would be great.
I'm going to write some up and email you. Thank you.
Okay, well, thank you very much.
Thank you. Bye.
Bye.